Afternoon, everybody. Welcome to this Pump Court Chambers webinar on TOLATA costs and mediation. I think the full title is Costs Interplay with Part 36, Offers and Negotiation. But clearly all of these matters are closely interrelated, and we'll try and take a holistic approach to the topic over the next hour. The webinar chat is open, so please feel free to pop any questions you might have in there as we go along. We'll answer as many as possible. Please don't be offended if we don't get to them immediately. Often a question will pop up and it's something that we're about to cover. If there are a lot in there, we may have to pick our favorites as we go. I understand that the cohort that I'm speaking to today is predominantly comprised of family practitioners, so I'll try and not assume an in-depth knowledge of the CPR. I'll take any points on civil procedure slowly, so apologies to those of you who are very familiar with that, but hopefully there'll be plenty for everyone as we go. Thanks very much, and welcome to my co-presenter Victoria Ellis, friend and colleague from Pump Court Chambers. Victoria has got a very broad practice which covers matrimonial finance, TOLATA, 1975 Act claims, and much else besides.
Afternoon, everyone.
Splendid. Thanks very much. For those of you who've just come in the last moment, I was just welcoming you all to the seminar today. We're going to be covering issues pertaining to TOLATA, costs, mediation, Part 36, negotiation. Those are all closely intertwined, but as I said, we'll take a holistic approach to them all. I'm going to start off by looking at the relevant costs regime. As I said, I understand that a majority of you are family practitioners, so I'm not going to assume too much knowledge there. Let's start at the beginning. TOLATA cases, while they can be, or TOLATA issues can be determined within financial remedy proceedings where you have interveners, they are often standalone proceedings or heard in conjunction with Schedule 1. So I'm going to start from the assumption that we're looking at standalone proceedings. Those will fall entirely within the civil procedure rules, and the first important from today's point of view consideration to that is that the family costs rules do not apply. We're under the CPR costs regime. What does that mean? Essentially, it means that costs follow the event. So crucial that parties are advised at the outset that an unsuccessful claim or an unsuccessful opposition to a claim can bring with it severe and unpleasant consequences. Obviously, it's important at the outset to consider what the equity in the property is that's the subject of this dispute, and try to take a proportionate approach to remedy and a proportionate approach to costs, because again, civil costs are very much driven by the principle of proportionality, both in budgeting, which we'll look at in a minute, and in assessment. General rule there is determined by CPR Part 44.2.2. Unsuccessful party will be ordered to pay the costs of the successful party, but court is given a very wide discretion, and there are circumstances in which it can and will depart from that, particularly in the circumstances that we're looking at today, which is to say cases involving offers, particularly Part 36 offers. So in exercising its discretion on costs, the court should consider all the circumstances of the case, including the conduct of the parties. Conduct in that context is litigation conduct, but it can include, and often does include, conduct before as well as after the issue of proceedings. And prior to the issue of proceedings, parties' behaviour should be guided by the practice direction on pre-action conduct, because you may be aware there are a lot of specific pre-action protocols in, for example, personal injury or housing cases. But here there's no specific protocol that applies to TOLATA cases, so the general practice direction on pre-action conduct and protocols applies. Cost budgeting, you may have heard civil colleagues complaining and gnashing their teeth about. The good news, but I'm afraid I'm going to mitigate this in a moment. The good news is that prima facie, cost budgeting only applies to Part 7 cases. So if your case is a Part 8 case, it shouldn't be cost budgeted. But the bad news is that most contentious Part 7 cases most contentious TOLATA cases properly belong in Part 7. And I'm afraid the courts are told that TOLATA cases issued under Part 8 are suitable for cost budgeting, and the court has a discretion to bring within the cost budgeting regime cases that are under Part 8, even though they're not automatically within the regime. There you go, Practice Direction 3E, paragraph 7.1, where cost budgets are filed and exchanged, the courts will generally make a cost management order under Rule 3.15, and if it does, the following paragraphs apply. So everything I'm about to say now will apply to all Part 7 cases, or nearly all Part 7 cases, and those Part 8 cases that the court pulls into the regime. Firstly, you have to complete a Precedent H. It's not the same as Form H. Precedent H is a much longer and more detailed document. It requires quite a lot of time. You have to fill in your anticipated costs of every one of about a dozen individual stages of the proceedings, and backdate it, include the stuff that's already happened, and break it down between solicitors, counsel, disbursements. It's quite an involved document. If you find yourself filling in one in, and you'll need a lot of figures for counsel, or always feel free to phone clerks. They're happy to assist with the relevant numbers. The budget for filling in the Precedent H is quite tight. Your recoverable costs of completing it will not exceed the higher of £1,000 or 1% of the approved or agreed budget. And all other recoverable costs of the budgeting and cost management process shall not exceed 2% of the approved or agreed budget. The idea behind cost budgeting was to try and keep costs down by the court having a proactive approach to setting them at an early stage. It can work that way, and does sometimes work that way, but particularly in medium and larger cases, I find it's really just adding another layer of costs to the procedure, and turning what would be a 30-minute directions appointment into a 2-hour costs and case management hearing. The good news, paragraph 7.3, if the budgets or parts of the budgets are agreed between all parties, the court simply records the extent of the agreement. It's only where there is disagreement that the court has to review the budget and decide what it's going to allow. Now, it says the court's approval will relate only to total figures for each phase of the proceedings, although in the course of its review, the court will have regard to constituent elements of total figures. And it's common to have a bit of to and fro between advocates at these hearings about, so many hours is being spent by this grade of fee earner. And those of you who are familiar with a summary assessment procedure, it's akin to that, but more involved. When reviewing budgets, the court should not undertake essentially a detailed assessment in advance, but just look at the global figures and decide if they come within the ambit of a reasonable range of figures. Um, Courts don't approve costs that are incurred before the date of a budget, so there'll be no retrospective consideration. But and this happens rarely in my experience, and only really where there is an eye-popping figure on the schedule. The court can record comments about figures that have already been incurred. Generally speaking, the district judge or deputy district judge undertaking this exercise has got a busy enough list that they don't want to involve in a retrospective view of already incurred costs, unless something really pulls the eye towards it. Um, Paragraph 7.5 provides that the court can set up a timetable for budget reviews throughout a case, but the good news is that that rarely happens. It's really only in very substantial litigation that you'd expect a timetable for reviews. What you do have to do throughout the litigation is keep your budget under review. And if you think that a figure has become inapt, either too high or too low, what you're meant to do is submit an amended budget. Again, in medium and even reasonable sized litigation, this is relatively rare. In my experience, I think, again, this is more here to deal with complex, lengthy litigation, but it can happen, and it's something to be aware of. For example, if you were to settle several issues in a case, then it might well be appropriate to review the budget. Or if you had a timetable for, a time estimate for trial radically altered, it would be appropriate to review your budget. Parties at the after that hearing then refile and reserve their amended budgets. Litigants in person aren't required to serve budgets, and parties represented by counsel under direct access are still litigants in person. What I find it's helpful to do, and this often happens at an early stage of litigation, is you'll have somebody who is a litigant in person at the CCMC, the Costs and Case Management hearing, but they will indicate that they're intending to instruct lawyers. It's a good idea then to have a line in the directions that those lawyers file a budget within 21 days, say, of filing notice of acting. It's normally a reasonably straightforward exercise for them, because they will have the benefit of the approved budget of the other parties from which to estimate those figures. You're not expected to be clairvoyant. If interim applications come up that weren't anticipated, they are simply treated as outside of the budgeting process. That I think is the key elements of cost budgeting. The other part of the CPR, which is essential to have in mind right from the off, is Part 36 of the CPR, and particularly those of you who practice principally in matrimonial finance. There'll be an element of nostalgia perhaps attached to this. It's sort of called a bank plus plus plus. It's a really potentially draconian regime. But the important thing to bear in mind for those of you, and Victoria will have no idea what I'm talking about, but those of you old enough, as I am, to remember the days pre the CPR, where the rules of Supreme Court and the County Court rules, we didn't have anything akin to Part 36. Sometimes parties would make each other call to bank offers, but the proper way of going about it was having a payment into court. And you would literally pay the money into court as it would sit in the court funds office. And then if the other party didn't beat that, they would have similar draconian consequences to those that now arise under Part 36. But it was an administratively burdensome process. Money would have to be paid in and out of court. And when they came up with the CPR, they thought there's really something that we can do without what's wrong with the parties simply making offers to each other directly. So what is new in part? Sorry, Victoria, you about to say? No, sorry. Can we go back one?
Yep,
There you go. Thank you. Um, no, forward one.
that one.
Nope, that's the one. Thank you.
That's right.
Um, um, what is new and interesting, and I appreciate I'm saying new about something that happened in 1996, which ages me horribly. What is different about the CPR from what came before it is the provision that you can make an offer prior to the issue of proceedings. Obviously, the benefit to making a Part 36 offer prior to proceedings is that then all of the costs are caught by your offer, and the punitive consequences of failing to beat the offer will fall on the whole of the costs of the proceedings. Um, let's have a look at some features of Part 36. It, some of what I'm about to say, I suspect those of you who are less familiar with Part 36 will sit there and think, why on earth does that need to be said? Well, the answer is that, as obvious as some of these things may seem to us, prior to Part 36 being implemented, there were debates about these things and cases that went each way, so it was felt necessary for the Rules Committee to clarify it. Part 3694B says that you can provide for your offer to be withdrawn automatically after a period. And we're all very familiar with offers being made in terms of, this offer is open for 21 days, and if not accepted by then, it's withdrawn. That's fine. That is open to you. But if you do that, then if the offer is not accepted prior to it being withdrawn, and you then go to trial, you don't get the benefit of it as a Part 36 offer because it's not still live. What should be the position is that if it's not accepted, let's say you're making a claimant's offer, you say this is available for acceptance, but you've got to pay all of our costs, and this is a consequence of Part 36. If you accept a claimant's Part 36 offer, you've got to pay all of their costs to be assessed if not agreed. 3695 confirms that improving an offer doesn't withdraw a previous offer, and this used to be contentious. So if I'm a defendant and I offer £100,000 to a claimant in my first Part 36 offer, and then months later offer them £200,000, they take that to trial and are rewarded 50, I get the benefit of the first offer and the second, and that makes that clear. The offering to the offer of 200 doesn't withdraw or nullify the offer of 100. 36, 13, 4 and 5 sets up a strong presumption that if a party accepts late, that is outside of the prima facie 21-day period, they are paying the costs from the end of 21 days of the other side. If you're a claimant, that's relatively straightforward. It's just you pay their costs right up to date. If you're a defendant, what that means is, let's take my example again. I offer the claimant £100,000. They don't accept it within 21 days, but 9 months later, a fortnight before trial, they decide they do want to accept it. What that means is that the presumption is that they will be paying my costs from 21 days after I made the offer all the way through to the date of acceptance. And Part 3617 sets out the considerable consequences of success or failure under Part 36. And those include penalties, interest, being denied costs that you might otherwise have obtained, interest on costs. I'm not going to go into all the gruesome detail here because it's something that could take up about half an hour on its own. But it's not something to be underestimated. I often find one of the great strengths of making a Part 36 offer is it compels one's opponent to sit down with the client and explain all of that unpleasantness. The formalities surrounding Part 36 are relatively easily complied with because there's a very handy form N242A. Generally speaking, unless there's some particular glitch or complexity is the case, if you simply use N242A, go through it line by line, your offer will be compliant. If in any doubt, have a look at Practice Direction 36A. Offer has to be in writing. It has to state on its face that it's intended to have the consequences of Part 36, and it has to specify a period of not less than 21 days within which the defendant will be liable for the claimant's costs if the offer is accepted. So that is the basis of the offer. You can't make an offer as a defendant to say, well, you can make the offer, but you can't make it under Part 36. You can't make a Part 36 offer as a defendant that says, I will pay you £100,000 worth of damages, but I'm not prepared to pay your costs. Has to state whether it relates to the whole or part of a claim, has to state whether it takes into account any counterclaim. If you're dealing with litigation involving an estate, as a Victorian, I often involved in 1975 Act claims, and of course TOLATA claims often run in parallel with 75 Act claims, particularly where you've got claims by widows or sorry, unmarried partners of deceased people. Then you have to be slightly careful about this because you might want to provide that the estate pay the costs. So you might need to have some conversations with the executors or administrators, but that's probably slightly niche for today's purposes. Bear in mind that when you're making a claim under TOLATA, the court's jurisdiction is not a discretionary one. You're looking at declaratory relief, and it's directed to the parties in their capacities as trustees rather than in their capacity as beneficiaries. For that reason, you might want to be cautious making offers in money terms unless you have agreed valuations, because the court is likely in due course to make an order in percentage terms. You don't want to get involved in an argument about whether the value of your cash offer is or is not more than the value of the ultimate percentage. So it will often, although not inevitably, be the case that under Part 36 you're looking at making offers in terms of percentages. But then that will be complicated if you've got questions of equitable accounting, for example, running alongside. Try and tailor Part 36 offers to orders that the court may and indeed is likely to make to maximise your chance of having beaten them. So if you have got an equitable account and you've got a quibble about the party's shares of a property, have a careful think about how you're going to structure an offer in a case like that. Are you going to look at a global figure of settlement, or are you going to look at two elements of the claim and deal with them differently? Also, if you're absolutely convinced that you've got an express agreement case, or you may even have a document which you say records the parties' joint intention, if it's a 50-50 case, then it might well be worth making a Part 36 offer of 49.51, because that may give you all sorts of very significant benefits if you succeed on your 50-50 case. And of course, if you are prepared to forego that 1%, it's probably well worth it for early settlement. Victoria, I think I'm over to you.
You are.
Thank everyone very much indeed.
I think we're going to move on to the section now, which is about ADR. talking about the ways we can hopefully solve these matters without necessarily going all the way to trial. I know that many of you will be family practitioners, and we've had a real push recently within the family sphere to try and divert people into various different regimes. So when we used to do this talk a couple of years ago, it would be quite alien. With the rise of private FDRs, things have changed quite a lot. But for those of you who are new to this or don't do much ADR, just to remind you that it's a very similar sort of regime as you would have within family contexts. However, the Jackson ADR Handbook, always a good place to start if this is new to you. In relation to civil proceedings, have a look at the CPR, but in particular, there's quite a helpful Chancery Guide, which is on the government website, which will talk you through the way in which they approach ADR in its various forms within a civil jurisdiction. And a bit like where we're moving to in family, the civil arena has very much had an overriding objective that at every point we should be considering whether or not ADR is appropriate and whether we can try and resolve proceedings through those mechanisms. We'll always be obviously considering whether it's proportionate to do so and whether it's appropriate. But as we're going to discuss this afternoon, the court is becoming harsher and harsher about excusing people's refusal to engage in any kind of ADR. For those of you who are brand new to this, sorry for those who are more familiar, just quickly look at what we're talking about when we mean ADR. You have your usual discussions and negotiations between solicitors. You have mediation. You have early neutral evaluation, where you can get an opinion from a single appointed expert, for example, a barrister, and they can tell you what they think the outcome would be. You can do private FDRs. In relation to TOLATA contexts, they are quite good. It's the kind of case that is actually almost made for this sort of resolution. Or you can go to arbitration, where, as you will all know, there will be a binding judgment. And it's at this point that obviously I would be remiss to not remind you all of the fabulous colleagues we have in public court chambers who specialise in this. So public court have numerous mediators and arbitrators in the family, in the finance, in the children, in the TOLATA, in inheritance contexts. If you ever find yourself wanting to do mediation or arbitration, a private FDR, private DRA is our new offering that we have available. Please do feel free to contact the clerks, because they'll be able to point you in the right direction and hopefully find somebody suitable to help you. The big thing to bear in mind is that whilst we are moving in the family context, having consequences if we don't negotiate properly with FDRs, for example, it is slightly more codified now within the civil context that there will be real consequences, potentially very serious consequences, if you refuse to engage in some sort of arbitration, mediation, ADR, particularly if you've been invited to do so. And if you want a starting point, apologies, it's not exactly the most thrilling bedtime reading, but it is the place you probably want to start, is the case of Halsey. Because having had a shift towards ADR and the court's encouraging people to think about it, this is the case that really does set out guidance of what the court is looking at and what it wants us to be doing when we're considering whether or not this is appropriate. And if you are considering whether mediation, arbitration, any other form is appropriate, and I should say they're terrible in the case law, mediation is often used as the umbrella term for everything. These are the sort of things the court wants you to be looking at. So the nature of your dispute. TOLATA cases are inherently well suited. You will all know that emotions can be one of the most compelling things that can prevent settlement. Mediation, arbitration, somewhere where you've got time to unpack what's gone on within normally a family context, try and understand what the difficulties are and see if you can find a slightly unorthodox but probably quite pragmatic way around it you perhaps couldn't achieve in court. This is exactly when you should be considering types of ADR. The merits of a case will obviously be relevant. If you've tried other types of ADR and they haven't worked, obviously that would be relevant. The costs are always going to be relevant. And one of the things to bear in mind is you'll see throughout the case we're going to talk about, it's not just the costs of the claim, the merits of the quantification of the claim itself that you need to think about. It's that plus the costs it's going to cause everybody take this through to a trial. Delay, obviously, if you have a stay to take part in some sort of ADR, we're going to delay the resolution, but perhaps that might be something that is well worth our while, and given the current court listings, potentially going to mean a more effective and quicker resolution overall. You will also, knowing your clients and knowing the other side, need to factor in whether you actually think parties can be trusted. I say that with the greatest respect to all of our clients, we know some can't be, to come towards this kind of mediation, arbitration, early neutral evaluation in the right spirit and hoping to settle this, because you will obviously all bear in mind there'll be some clients who will need to hear it from a judge or a mediator or an arbitrator before they're going to think about moving and compromising. So when you've considered Halsey and you've got your list of things you're going to think about, let's think about what happens in practice. And the reason it's been taken so seriously, you'll see the PGF case that's set out there, because the judge upheld the decision of a lower judge to disallow a successful defendant the costs he would have been entitled to when the claimant accepted his Part 36 offer on the day before trial. So normally, when we talk about costs following the event, and you've been taken through Part 36 brilliantly by Mark, normally you'd be thinking, slam dunk, brilliant, we've got our costs. Except because the court found they hadn't been reasonable in relation to their approach to ADR, all of a sudden the successful defendant finds himself not being able to have what he would otherwise have been entitled to. And the particular part of the judgment which is relevant is obviously put in quotes here there, where the court firmly endorses the advice in the ADR handbook, that's the Jackson handbook I referred to earlier, that silence in the face of an invitation to participate in ADR is, as a general rule, of itself unreasonable, regardless whether an outright refusal or refusal to engage in the type of ADR requested, or to do so at the time requested, might have been justified by the identification of reasonable grounds. So if you take nothing else away from this afternoon, if you are contacted about mediation, arbitration, trying to resolve proceedings, do not ignore it. They helpfully do go on to give you some guidance of how you should approach it if all of a sudden you think this is a waste of time at the moment, we can't possibly engage at this present moment. If you think there are reasonable grounds to say no, or perhaps more appropriately, not at the moment, make sure you go back to the other side and you say that, because you're starting a paper trail to explain that you didn't outright reject any kind of ADR, you were trying to be reasonable and pragmatic in the circumstances. Respond promptly. Don't leave it for months and months and allow the other side to keep chasing you, because that way you're going to get yourselves into a pickle. Make it very clear why you are refusing. Obviously, everybody's allowed to say we're taking instructions, but you need to go back relatively quickly and explain why you're not going to deal with ADR at the time. It might be, for example, particularly in TOLATA context, you don't have the right disclosure. You're waiting for the conveyancing file. You're waiting for some very particular documents that you can't deal with without. It could be that you're saying, well, hang on a minute, we need to get a valuation first before we start this. They would be reasonable. Try, if you can, to refer back to Halsey, because you're showing that you understand the regime and the consequences of not engaging. But do not say at any point, we're just absolutely not willing to do it. We're not willing to engage. Because if you say that, you're going to get yourselves into trouble. Practice directions are really important. Reaction protocols are also really important. The court will, when assessing costs and assessing reasonableness, look at all of these things holistically and in the context. And at 16, we set there that they will look at non-compliance when dealing with requests to impose a sanction, either a request from the other side or one imposed by the court of its own motion. And that will include considering whether the party at fault pays the costs of the proceedings or part of the costs of one or all of the other parties, whether if they're at fault they should be doing that on an indemnity basis, and whether or not the party who's at fault has been awarded a sum of money that would be depriving of interest or some other specified sanction the court can put into play, because they do have, as Mark said, some discretion in how they wish to deal with this. If the party at fault is a defendant and the claimant has been awarded a sum of money, an order awarding interest on that sum for a specified period at a higher rate than would otherwise have been awarded is another thing the courts can do. I appreciate that's quite alien when we're talking about how we would deal with it in family finances, but you need to be aware that if you start getting on the wrong side of your judge in terms of costs in a TOLATA case, you can have harsher punishments potentially than you would have in other family spheres. And to be really clear, when we talk about unreasonable conduct, when we talk about non-compliance, that very much means not engaging in ADR if you're asked to. We then get into some of how the courts have started to apply this guidance. And Garrett Critchley is a really important case to be aware of. And just to take you through that, The claimant sought £208,000 in a letter of claim, but suggested they were open to ADR, particularly mediation. The defendant failed. And again, perhaps one of those things we all know is when you write stroppy letters back to the other side, particularly if you do it on an open basis, make sure that you're happy for a judge to see it at a later date. Because sometimes what you think is brilliant when you send that punchy letter back at 4 p.m. in the afternoon might come back to bite you, and that's what happens in this case. Because what the defendant says in this case, having had quite a reasonable offer to mediate, is that both we and our clients are aware of the penalties the court might seek to impose if we're unreasonably found to refuse mediation. We are confident that in a matter when our clients are extremely confident of their position and do not consider there's any realistic prospect that your client will succeed, the rejection is entirely reasonable. Unsurprisingly, the court may not have taken the same view. Frustratingly, even though obviously perhaps it was slightly unwise the way it was worded, the case went to trial, the claimant offered to settle for £10,000, and after trial but before judgment, the defendant accepted the offer to settle for £10,000 plus standard basis of costs. The claimant sought the cost of the whole case on the indemnity basis, and the defendant sought to justify their refusal to mediate on multiple grounds. A bit sort of, when you didn't do your homework, you tried to come up with excuses of reasons why. They gave every reason to the judge and it didn't get particularly far. What the judge particularly didn't like was the fact that they couldn't foresee at the start when they were offered mediation where the middle ground would be. The parties were far too far apart. They really disliked each other, so they didn't really see the point. And they felt that given the sums being talked about and the sums that had been settled for, it would have been completely disproportionate to go to mediation. The judge rejected all of their arguments, and basically made the point that multiple judges have now made, which is this is exactly what mediation is for. Particularly, as I said earlier, in TOLATA contexts, when you're looking at people whose relationships have broken down, as Mark said, perhaps had a death in the family, you have sensitive scenarios, and you're having to navigate that. Having the time and the space of ADR can be exactly what is needed to make very raw, emotional clients on both sides come to the table and think about a way forward that can work for everybody. On that basis, he ordered the defendant to pay costs on the indemnity basis and made the following quote: "Parties don't know whether in truth they are too far apart unless they sit down and explore settlement. If they are irreconcilably too far apart, then the mediator will say as much from the first hour of mediation. That happens very rarely in my experience." And I have to say, in almost 15 years, I don't think I've ever had a mediation that's fallen apart within the first hour. Even if it's not ultimately successful, and I see Mark shaking his head, every mediation can have a good stab and have a good go at this and see whether you can resolve it.
I think my worst ever was about 90 minutes, but that was because an insurer had a hard limit on what they were able to do, and it quickly became clear that the claimants weren't ever going to accept that. So,
fair enough.
What can one do?
Mark said it's really rare. In Thacker and Patel, the defendants did not ignore or refuse to mediate, but they dragged their feet, they delayed, they messed around, and the judges found that quite reasonably, at some point, the claimant just lost confidence in the whole process. And Jackson says that the message which the court sends out in this case is that in a case where bilateral negotiations fail, but mediation is obviously appropriate, it behoves both parties to get on with it. If one party frustrates the process by delaying or dragging their feet for no good reason, they will merit a cost sanction. And in that case, the court ordered the defendant to pay 75% of the claimant's costs, ordered the claimants to pay the defendant's costs of the counterclaim. Now, we know that. We've seen that in the family jurisdiction when you have people who just don't provide the disclosure you need, and you go through repeated attempts and adjourn to FDA, and at some point a judge says, "I've had enough." You probably find that a civil judge is going to have a little less tolerance than perhaps the family judges do. If people are messing around and they're abusing the process, obviously, there are going to be cost consequences that bite quite quickly. You've got another case in Northrop. You have Ramsey J deciding that a refusal to mediate was prima facie unreasonable, should not result in a cost sanction because of the relevant conduct by the refusing party who made a without prejudice savers to cost proposal. This case is basically saying, yes, we will punish people who mess around, but we're grown-ups and we'll look at the whole circumstances of the case. And if both parties have behaved badly, we're not necessarily going to suggest the refusal to engage in ADR, for example, is going to always be the trump card that means you can then do whatever you want on your side because they're definitely paying your costs. The court will always look at this in a holistic and in the round. I find this case incredibly interesting, public policy perspective. In Laporte, you have the Commissioner of the Metropolitan Police basically saying, we cannot possibly, was their argument, mediate or offer to mediate or engage with every single potential claim you have made against us, because it's all we would ever do. It was a situation in which they were pretty sure it's a vexatious claim. They felt that it would be daft to engage with it. It'd be setting a bad precedent. They had to have some guidance and draw the line somewhere. And on the face of it, their position looked quite reasonable. Court, not so sure. And so the defendant, who was successful in every substantive issue, proving their point that there was nothing in this case, only got 2/3 of their costs. And that was because they had failed, the court found without adequate justification, to engage properly in the ADR process. And I think this is possibly one of the cases when you realise the courts mean it when they say there are going to be sanctions. Possibly one of the cases which you would think they would be sympathetic towards and they might take a slightly lighter touch. They didn't. What they chose to do instead was to make it very clear all the threats they've been making since they started implementing Halsey, they meant them and they're willing to see them through. In Kelly and Kelly, you again have one of the examples when the court does come down on the side of the person who said enough is enough, I'm not mediating. And we'll all have had clients and we'll all have had cases when, despite the best efforts of one party, the other side is just not paying ball. And the courts, again, a bit like some of the other cases we've talked about, have said they will look at everything. They will not be blinded by just what has happened in relation to ADR. And in this situation, father and son, quite sadly, they've been trying to resolve their case. They'd had 2 attempts at mediation, proper attempts, and each time the claimant had failed to honour the mediation agreement. And when they came back a 3rd time and said, well, you must mediate with us, otherwise, there'll be cost consequences, the defendant said, you know what, we've had enough. We're just not doing it. This is a waste of everybody's time and money. We've been here, we've done that, and you're not engaging. And the court found that in that particular situation, the refusal was understandable and reasonable, given the risk of further broken promises, further costs being incurred, and they awarded him his costs on the indemnity basis as claimed. So the courts aren't blind to the fact that there will be circumstances in which it's appropriate to depart from the quite strict stance they're taking in relation to this. In relation to the case of Gore, which you've obviously got set on the next slide, you have a dispute between neighbours about a claimant's right of way to a shared driveway for access. Defendant's right to obstruct the driveway to unload the lorries for their wine business, versus the claimants wanting to be able to access their property and be able to park there when they wanted to. Trial judge found in the claimant's favour and ordered that defendants pay the claimant's costs. The defendant appealed, arguing that the claimant failed to engage with their invitations to mediate, and therefore the judge was wrong not to have made some deductions or allowances for the claimant's costs. The Court of Appeal upheld the lower court's decision. So this is one of those cases when if you're looking for some sort of support, if you've got into a bit of if your clients have got themselves into a pickle by not engaging, this might help you. Because in that case, Patton says that speaking for myself, I have some difficulty in accepting that the desire of a party to have his rights determined by a court of law in preference to mediation can be said to be unreasonable conduct, particularly when, as here, those rights are ultimately vindicated. Failure to engage, even if unreasonable, does not automatically result in a cost penalty. It is simply a factor to be taken into account by the judge when exercising his discretion. I do wonder, however, that obviously taking into account the way the Court of Appeal have approached this is the general policy they also have, that they tend not to try and interfere too much with lower courts' judicial discretion unless there's a real error or something they need to correct. I do wonder whether that has a part to play in this, but it's a helpful case if you're looking for something to hang your hat on to say, hang on a minute, people still have the right to be able to go to trial and have their cases heard by a judge.
Victoria, if I may just
Yes.
chip in very quickly. I think it tends to be the case that not only is the Court of Appeal very respectful of the exercise of discretion by lower courts, but over time they've shown that that is particularly so when it comes to cost decisions, because they know how emotive costs can be. and they're really reluctant to give people the slightest encouragement to appeal cost decisions.
Yeah, I completely agree. And you can almost hear the resignation and weariness when you have your substantive judgment and then you have four further judgments about what's happened with the costs. I completely agree with Mark. Having done a quick canter through the consequences, let's talk about the fact that all of you are brilliant. You're not going to get yourselves into this kind of mess, and what you're going to do is be really proactive at looking at ADR. Some things that we think might help. Be really careful when you're choosing your mediator, your arbitrator, whoever you're going to have. I know this sounds really daft, but make sure you choose somebody who does that area. You would think it doesn't happen, but it has happened on occasion when I have rocked up as counsel for a party and a mediator, and myself and my opponent have realised quite quickly that our mediator, lovely as they are, and I'm sure a brilliant mediator, perhaps not as specialised or familiar with the law, which can create some problems. Remote and hybrid ADR is something that perhaps 5-6 years ago we wouldn't have been considering. The pandemic taught us well that it can work brilliantly. Now, sometimes it's better, and you will take a view with your clients, have everybody in the same place where you can bang some heads together. But sometimes, if you've got a very vulnerable party, you've got people abroad, somebody who's not very well, having the comfort of being in their own homes to engage in this can really be a benefit. It can slightly release the stress. You can send people off to have a cup of tea and have a break in the comfort of their own home, play with the dog, whatever they want to do. And sometimes having those remote or hybrid sort of scenarios can actually make settlement and resolution more likely. Costs of the mediation, well, standard practice is everybody pays for their own team and will share the costs of the mediator or the arbitrator and any premises. What I would say is bear in mind is that more and more mediators, arbitrators, chambers, professional organisations that offer this, they're putting sort of a cut-off time in. So everything will be included up to, example, 6:30. And at that point, you might start incurring additional costs afterwards. So if you're looking in and making inquiries, make sure you ask whether there's a cut-off or deadline after which further costs will be incurred. Drawing up the agreement. Any of you who've ever done an FDR or settled a finance or a children case will know you reach a deal and then all of a sudden you've got to draft those horrendous orders that take forever with all the detail that goes with it, which can take hours. It always invariably takes longer than you think it's going to. Invariably, the parties will get stuck on a particular detail that you didn't think was going to be controversial. So whilst you're having to take into account if you keep your mediator or arbitrator for hours, you may incur a charge, you might want to make sure some of your bigger issues are definitely agreed and the practicalities are agreed before you let them go, because what you might need is a slightly further indication to get you through a particular roadblock you didn't see was coming. Ideally, getting it done on the day is always better. Ideally, getting everyone to sign up to it when they're there and they've got their legal teams with them and everyone understands the discussions you've had is always going to be beneficial, because otherwise people are going to potentially go home. They're going to talk to their partisan team about it, wives, husbands, parents, friends in the pub, and all of a sudden they're going to perhaps regret the agreement that they came to or suddenly change their mind, or everybody else has their say and it's likely to unravel. However, there will obviously be times that you are in a situation when you can't do everything because you need to potentially check with an insurer or a particular expert about how you're going to structure something. If you think you are going to have those problems, if you can identify them earlier and speak to those third parties who may have an input prior to the mediation or the arbitration, that will always be better. Because if you can get it done on the day, it's going to be beneficial. We always appreciate that sometimes that's just not possible. When you find yourselves in those completely, hopefully quite rare, but they happen situations when you thought you've agreed it, you've got your big heads of terms, and then all of a sudden the practicalities, the implementation of this order, the small bits that are going to matter mean that it sort of falls apart afterwards. Because despite the fact you'd agreed perhaps that you're going to sell the house and they'll get X and Y, as Mark said, issues of ethical accounting rear their head. All of a sudden the valuation isn't what you expected it to be. Remember the case of Frost and Wake. Just keep it in your back pocket, because whilst you have a duty to advise your clients as to the mediation process and the status of any agreement reached, you're not wizards, and the court aren't expecting you to conjure finality from a provisional agreement that's fallen apart. So whilst it's better to get it all done if you can, remember that there is a limit to the magical skills the court is expecting you to have in terms of finalising agreement if the parties really aren't going to let you do that and aren't going to let you reach a stage when what you've agreed can become enforceable or implemented. And that's really a quick canter through, because appreciate we're encroaching into your lunch breaks of ADR, what obviously this chambers can offer, what courts are asking us to do going forwards, and some of the consequences if we don't play by the rules that they've been quite clear they are setting down. Mark, anything you want to add as a final hurrah, given you are chief leader of our inheritance team and do lots of mediation yourself?
No, I suppose what I would say is for anyone who is concerned about civil mediation and unfamiliar with it, I'm an enormous supporter of it. I became a mediator about 20 years ago because I found myself going to mediations and they were succeeding and succeeding and succeeding in cases which I was very skeptical had any prospect of settlement, and yet they did. And I went and did the training, hoping to gain magical insights into understanding why it was so successful. And I'm 20 years down the line, and it still succeeds time and time again. And I still don't fully understand what the magic is, but it's very telling that it came into the system through the Court of Appeal. Pre-Halsey, the Court of Appeal set up a mediation scheme. And after a few years of stunning results, someone at the Lord Chancellor's Department, as it was then called, must have said, well, hang on, if this works in a self-selecting group of the most insoluble cases that have made their way to the Court of Appeal and got permission to appeal, shouldn't we be trying it much further down the line? And there it is. And the other thing I would say is, as long as you've got a mediator with the right experience, don't be concerned if those proceedings also encompass Schedule 1 or 75 Act or even matrimonial finance as an intervener. Thank you all very much. Thanks for some really interesting questions at the end there. I hope you've all enjoyed it. And I hope you'll be tuning in next time when our colleagues take on another bite of TOLATA. Thanks, everyone. Have a very pleasant day. Bye bye.